Welcome back again. The final seminar to take place on the main stage this afternoon is being delivered by Brodies. This seminar covers some really important issues for farmers, including farming partnerships and succession planning. Something for everyone during this presentation. And this is quite personal to me at the moment when I've got a 21-year-old son trying to get his old dad out of the driving seat at our business back home. So it gives me great pleasure to hand over to Clive Phillips to start this seminar.
Thank you very much, Robert. As I was listening to the introduction there, my signal was very poor, so I'm hoping we're not having too many difficulties. If we do, we will move on to another presenter. But I'd like to welcome you all to the Brodies presentation. What we thought we'd do today is because everyone is spending a bit more time at home, that we would concentrate on giving farm businesses a little bit of a health check. And so we're going to cover partnerships, succession, matrimonial, not from the point of view of just when things go wrong, but also from the point of view of avoiding problems if things do go wrong. And then lastly, the really important topic of utilities and telecoms, because that is a big issue at the moment with many of the operators now approaching farmers for access and rights over their land. There is same procedure as the previous presentations. If you have any questions, please put them in the chat box and we will try and answer as many as we can at the end of the session. I'll introduce the individual speakers as we go through the presentations, but I will kick off first of all talking about partnerships. So I'm hoping that the slides will come up. Good, thank you very much. So partnerships, I'm going to cover what constitutes a partnership, how you create it, the relationships between partners, termination events and valuation, land and legal rights, and leases to partnerships. These are some of the key critical moments or milestones in the life cycle of a farming partnership. Farming partnerships are widely used in the agricultural sector, and I think that's partly because it lends itself very well to family setups, family farms, which are still the hub of most farm businesses. The other aspect to it is that partnerships don't have limited liability, and limited liability hasn't really been an issue or a concern in agriculture, at least to date. So that's meant that partnerships are widely used. They're also very, very flexible, and that flexibility is both good and it's bad, because it means that things can change within a partnership very quickly and have quite significant consequences for the partners. So it's regulated by the Partnership Act of 1890, which is an old and tried and tested piece of legislation. And what the Act effectively does is provide a default in the event that the parties have not agreed something else. And the problem with that, of course, is how do you evidence what the parties have agreed? And that's where the flexibility that partnerships have can also be a bit of a disadvantage. So the message there is that it's very important to record the partnership structure in writing, because a partnership itself doesn't in fact have to be in writing. And if you have a partnership that is not in writing, known as a partnership at will, it can also be terminated at will. No notice period, someone can just get up, get to the breakfast table and announce that the partnership is at an end. That is a significant risk to any farm business. So I would encourage anyone that is operating a partnership at will to consider getting a written partnership agreement in place. There's no formal registration process for partnerships, so there's no way that you can go specifically to find out if a partnership exists or not. It all comes down to there being partnership agreement and or the actings of the parties. And then over time, the partners may vary the terms of the partnership, and they may do this just by their actings, or they may do it by reflecting the new changes in the partnership accounts. So, for example, if you have a partnership agreement that says profits are shared 50-50, but the accounts start to share profits 70-30, and the partners do that every year and sign off on the accounts, that will effectively vary the terms of the partnership. So, looking at the relationship between the partners, getting the profit shares is really important. Getting the profit shares right is really important. And it's important to understand the distinction between revenue and capital. Because if you do not separate out different profit shares for capital and revenue, then the same profit share will apply to both revenue profits and capital profits. And capital profits are generally the profits generated on disposal of capital assets or on revaluation. And that can throw up some odd results, because the partners may wish to share operational profits on a 50-50 basis or an equal basis, but they may agree that one of the partners has contributed more land into the business, and therefore, if there's any capital profits, he or she should get a larger share of those capital profits. If you don't say anything, then the revenue profit sharing ratio will also determine how capital profits are shared. And that's often a surprise to people, because they assume that the capital profits will be shared in accordance with the ratio of the actual capital accounts. There's lots of options when you take new partners into a partnership. They don't have to go in as full equity partners sharing all of the profits of the business. You might give them a fixed share of profits to start with. You might give them a small share and gradually increase that over the years. So there's a lot of options there to create a structured progression for new or young partners to come into the business. It's also possible for existing partners to separate out their capital accounts, which is holding the land. And this is by using what's called a heritable property account, so that any uplift in value in the heritable property accounts, i.e. the land, will go to those partners rather than all of the partners. You need to think about, should the land be in or out of the partnership? And that's a big discussion, and I can't really cover it in detail here, but it's really important to get detailed advice on that. And you need to be careful about the accidental inclusion of land in a partnership. So even although the title might sit in the name of individual partners, if the land appears on the balance sheet and the partners sign off on it, then over time that asset will become a partnership asset and then subject to all the terms of the partnership. Quick word on decision making. There's often a bit of confusion about this. Decision making in partnerships is not like a company. It's not based on votes per share or anything like that. Every partner has a right to be heard and is involved in the decision making process, and decisions required to be taken unanimously. However, if you want to agree something different, you can say so in the partnership agreement. So you might introduce majority voting, or you might give someone a right of veto in the event that there is all the party, you can't get a majority decision. So it's important to think about that and important to understand that, because just because you might hold the largest financial stake doesn't give you the largest say. Termination and valuation are two critical elements in the partnership's life cycle. If there is a change in the partnership as a result of a retirement, a death, a resignation, or the assumption of a new partner, in law, that is the creation of a new partnership. Most partnerships will provide that the continuing partners have the option to acquire the outgoing partner's share. And the outgoing partner doesn't have a right to walk away with assets. They only have a right to cash. Very often there's critical timetables in the partnership agreement, so that if the continuing partners wish to continue the business, they have to make that election within a certain period of time. So it's important to look at that very early on in the event of a change. It's also important to understand the valuation process, and there's different approaches to valuation. Some partnerships provide that you just take the value from the last balance sheet, and other partnerships provide for a full revaluation of assets. They can bring very different results. Relying on the last balance sheet of the partnership means that it tends to protect the business and give the outgoing partner a smaller share. The revaluation tends to favour the outgoing partner and means that the continuing business may have a larger share to pay out. There's pros and cons of each, but it's really important to understand what your partnership agreement says and consider, is it actually doing the right thing for your business and your family? And we've talked about capital profits and revenue profits already. So land is critical in partnerships because it is of such a high value, and it can really boost the impact of these valuation events. So very important to understand how the capital profits are shared. You should consider ring fencing heritable property accounts if you want to make sure that the benefit of the land value is only going to be shared amongst certain partners within the partner group. Consider, is the land on the balance sheet or not, and if it isn't, and if it's you need to consider if the land is on the balance sheet or not, and how the title deeds are held to get a proper understanding of whether farms actually form partnership assets or not. It's not unusual for us to see partnerships that have some land which are partnership assets and some land that isn't, and it can often be a surprise to partners when they get a complete and full understanding of how the land is actually held and owned. It's worth mentioning too that land in a partnership is deemed as movable because it's the partnership that owns the land, and the partners individually have an interest in the partnership. They don't have a direct interest in the land. So that means that the value of the land is effectively treated as a movable asset, not land for succession. And my colleague Hayley Robertson will touch on that in a bit more detail when she talks about legal rights in her presentation. But it is possible to write something into the partnership agreement called a Section 22 declaration, which is designed to mitigate against that risk, to reduce the impact of a potentially hostile legal rights claim resulting in a large liability for the partnership. Quick word about leases. Tenants, there are two aspects to this, and apologies for the typo in the first line, but tenants are entitled, tenants of a farm are entitled to farm through the vehicle of a partnership in which they have a significant interest. So they can hold their tenancy as an individual, but operate their business in a partnership, and that will not put their tenancy at risk. They obviously have to have a significant interest in that partnership, but it is accepted that that is a method that they can operate. There aren't, on the other, from the other side of the coin, if a partnership is the tenant of a lease, it is more problematic, because if a partnership comes to an end, then the lease will fall, and it falls automatically, and there's nothing that you can really do about that. It is possible to write in specific provisions into a lease which will say that it will not fall in the event of a partnership change, but that has to be done by agreement with the landlord, and it's a little bit unusual to see. So it's important that if you do have a partnership with a lease, to understand what would happen to your lease in the event of a change in the partnership. And if the lease is potentially at risk, then consider whether or not you should open a dialogue with your landlord to consider or plan for what would happen in that event. Otherwise, you can effectively bring the lease of a farm down almost instantly, well, effectively instantly, on the change of a partnership as a result of death. So very quickly, top tips: keep your partnership agreement up to date, keep minutes of key partnership decisions so that you can evidence what's been decided. Consider whether you should have the land in or out. Check how the profit shares are set. Make sure that you understand the termination mechanisms and valuation, and check any lease arrangements that you have. And generally just keep your partnership arrangements under review as an element of good housekeeping, and to make sure that your partnership is sustainable and robust and ready for the challenges ahead. Right, I'm now going to introduce you to Hayley Robertson, who is a managing associate in our personal and family team, and she is going to talk to us about succession. So I'm hoping that the slide.
Lovely. Thanks very much, Clive. So, yeah, first and foremost, when we are looking at succession planning, there are a lot of things that we need to consider. But today, we only have 15 minutes to cover this topic. So I've just chosen perhaps some of the more important factors to consider. So first of all, we'll just consider succession planning generally, then look at the very important topic of inheritance tax before considering legal rights, which Clive has already referenced, and then finally touching on the importance of having a will in place in the context of good succession planning. So what is succession planning? It's the process of planning or implementing the transmission of wealth, typically from one generation to another. And of course, this is not just for farmers, it's for anybody who has assets. However, the position for farmers has particular themes due to the nature of the assets, the business and the business structures often involved. When considering your succession planning, there are three crucial questions which often then lead to a fourth question. The first being, who will inherit your estate? Identifying your heirs, and particularly where there's a farming business, what's to happen to that, and who should take that over. What will they inherit? And that links back to what Clive just mentioned there in terms of working out just exactly what you own personally, what's owned by the partnership, etc. Then when will they inherit those assets? And when we talk of succession planning, we are not just talking about the position on death. It's very important that these discussions and these thoughts happen during life and not too late in life. So often lifetime gifting is one very good way of beginning at least your succession plan. And then, as I say, those answering those questions then links on to really how your beneficiaries, your heirs, will inherit. And that's largely a question for the lawyers in conjunction with yourself to decide on the most appropriate legal mechanics in achieving your overall succession plan. I've mentioned here on the slide that this can be a difficult process to navigate for anybody, but we very much recognise that there are some particular challenges for farmers and farming businesses, but of course we can help with that. Moving on then to consider the very crucial consideration of inheritance tax. And now this often is the driver to many people's thoughts in terms of beginning their succession planning. To summarise, inheritance tax is typically a tax that bites on death, but importantly, it can also bite in relation to certain lifetime gifts. And really, that is gifts to trust, depending on values and types of trust, and also any gifts that are made in life where the individual making the gift then does not survive the 7 years, and on death that gift becomes chargeable to inheritance tax. Broadly, the charge to inheritance tax is at the rate of 40%, and that's 40% on the value over whatever the thresholds are in place at the time of death. Where we have a married couple or civil partners, the inheritance tax typically bites on the second death, and that is due to the very valuable spouse exemption. So on the first death, if the majority of the assets pass to your surviving spouse, there will be no inheritance tax to pay on the first death, but then it is on the death of the survivor where any assets in excess of the thresholds are charged or are potentially liable to inheritance tax at 40%. And just to summarise on that, each individual can leave assets up to £325,000 free of inheritance tax. That is transferable between spouses. So effectively on the second death, the surviving spouse, has the benefit of £650,000. And then on the top of that, since April 2017, we also have the very complicated residence nil rate band, which, as the name suggests, is only applicable in relation to your interest in your residence. There are lots of complications about how that applies, and it doesn't always apply, but on the face of it, therefore, spouses or civil partners have, broadly speaking, an IHT threshold of up to £1 million. Anything over that is taxed potentially at 40%. On top of that, we then look to see what further exemptions or reliefs are available to potentially reduce any anticipated inheritance tax liability on the second death or on first death where there is no surviving spouse or civil partner. And this is the really important message from today, certainly from my perspective. There are some extremely valuable reliefs that are available, and particularly valuable and important in the farming business world. And these are agricultural property relief in the first instance, and also perhaps to a lesser extent business relief or business property relief as it was called. The principal policy objective of agricultural property relief and also business property relief is very clear, and that is an attempt by the government to basically prevent the sale or break-up of businesses or estates, farms, in order to pay any inheritance tax that's due on the death of a business owner. Now, these are big topics in their own right, and I'm conscious of time today. So just to say that, broadly speaking, taking agricultural property relief, first of all, that is, as the name would suggest, available in relation to land that is occupied for the purposes of agriculture, together with appropriate buildings and farmhouses used in conjunction with that land. And there are certain criteria. The property must have been owned, occupied by the owner for the purposes of agriculture for 2 years, or owned by that person for 7 years, but occupied for someone else for the purposes of agriculture for that period. Then, depending on the use and the occupation of that land, that then determines whether 100% relief is available or 50% relief. Agriculture itself is not actually defined in the inheritance tax legislation, but broadly it includes horticulture, growing fruit, the intensive rearing of livestock or fish, but it also includes woodland that are ancillary to farming operations. Beyond that, things to point out, I've mentioned here, beware of the traps in my slides. In relation to farmhouses, this is well documented. It's been in the press over the years. In order to get agricultural property relief in relation to your farmhouse, it must pass what's termed the character appropriate test, i.e. the agricultural land must be the dominant feature and not the house. And also, relief will only be available in relation to the farmhouse if the farmhouse itself is the centre of the farming operation. That is a particular consideration perhaps for retired or older farmers, and it's certainly something that we can provide advice on. Beyond that, there are often issues with the reliefs where perhaps there's been some diversification on the farm or on the land, and particularly where you're a landlord, APR will only be available if your tenant is carrying on agricultural activities, and if he diversifies into something else, then it will not be available. Finally, on agricultural property relief, important point just to stress that the relief itself is restricted to the agricultural value of the property or the land. Hope or development value and value of sporting rights are not included or not covered by agricultural property relief. And as a rule of thumb, this is broadly at between 60 to 70% of the market value of that property, which is what inheritance tax is based upon. If agricultural property relief is not available, it may be possible to claim business relief, and again that is in relation to business property, and similar to APR, agricultural property relief, depending on what it is you own, the interest, etc. It's at 100% relief or 50% relief, and again similar to APR, there are minimum periods of ownership, and crucially, any business interest where you're claiming business relief must not consist of wholly or mainly making or holding investments. And you may have seen in the press last week or the week before, there was actually a case on this topic, and it was holiday lettings, and it was not, business relief was not given in relation to that particular asset. And finally, clawbacks. We also need to be careful where you are claiming agricultural property relief or business property relief, that when in life, if you gift property which qualifies for these reliefs, but then don't survive the 7 years from making the gift, there is a potential that you will lose the relief because it's assessed on the earlier of the death of the donor or the donee. So that is a very quick summary, and hopefully you can see from that summary just how potentially complicated it can be, and therefore the importance of making sure that you assess, have a look at what's in your land, assess the value, and also take professional advice to make sure that you are securing the reliefs as extensively as possible. Moving on to consider legal rights. As Clive mentioned earlier, legal rights are particularly important where you have partnership assets, but more importantly than that, for your succession plan, they must be considered. Legal rights are a distinctive feature of Scots law, and broadly they are a protection from disinheritance for spouses and civil partners and children. And when we mention children, that also includes adult children. There's no age limit there. And important to stress that legal rights apply to every estate, whether there is a will in place or not. That I'm not sure is widely known, so we always mention that to clients. Where you are survived by a spouse and children, the spouse and the children as a class are entitled to 1/3 of your net movable estate, and where you're only survived by a spouse, that increases to 1/2, and where only survived by children, it is also 1/2. So because legal rights apply to only the net movable estate, then, as I've mentioned here, generally speaking, therefore, land and buildings are not included within the legal rights pot, and therefore can be left to who you wish in your will. However, as with so many rules, there are exceptions, the big exception being that as mentioned by Clive, land held in a partnership is treated as movable property. Therefore, unless you have the Section 22 declaration in your partnership agreement for legal rights purposes, the value of that land is included in the legal rights pot. Similar to land held in a company. And just on this, the final point on this topic, there is no way to prevent a legal rights claim in the sense of spouses and civil partners and children have an entitlement to this. They will be given the option on a death, do you want to claim or disclaim? And of course, in the normal circumstance, it is anticipated that children would normally, if they get along with their surviving parent, or indeed their deceased parent, then they'll be happy to go along with, if there's a will, the terms of the will, in the knowledge that in due course they will anticipate that they will inherit, on the death of the second parent. However, that is not the case where there are perhaps estranged children, or perhaps issues, in the future whereby whatever provision you make for that child, they'll have an election. They either take what provision you give for them under the will, or they can claim their legal rights. And sometimes, children can decide to do that. So what I would say on legal rights is important message. Normally, legal rights are not an issue. However, they can be, and if they are, it is particularly important for a farming business to take advice as to how you mitigate and plan during life in order to protect your assets and your business. And finally, conscious again of time, this is just a final very, very important consideration to succession planning. Clearly, this is very crucial that you have a will in place in relation to any successful succession plan. I've mentioned here that the default law is not your friend. The law in this area is regulated by the very old Succession Scotland Act in 1964, which does not take into account modern families. And interestingly, depending on what is in your estate in terms of assets and values, sometimes your siblings can be preferred to your spouse, can also pass assets down to children, again, in preference to your spouse. And really is just inflexible and potentially costly, might not do what you want in terms of protecting the family wealth, and importantly, probably very tax inefficient, and again, really is totally out of your control. So the simple advice is take control back in this uncertain world where there are so many unknowns, Brexit, COVID to name but a couple. Put a will in place, seek specialist advice, and important to note as well that a will is not just about who should inherit. It can also take into account making sure you maximise the tax reliefs, and it can also be an extremely flexible document. So in instances, for example, where you aren't 100% as to who you want to take your business forward, trusts can be a very useful structure in that sense. And importantly as well, if there are any vulnerable beneficiaries, children going through a divorce, etc., there are many things that can be done to protect your inheritance or their inheritance from those types of issues. And the final point is that if you have a will in place, that's great. What I would say though is that make sure that you do review that will from time to time to check that it still remains appropriate, both in terms of your family circumstances as they evolve, business circumstances, and crucially, particularly at the moment, any evolving tax changes, etc. So that was a bit of a fly through some very important topics in the succession planning world, and I will now pass over to Sarah to discuss some matrimonial issues.
Thanks very much, Hayley. That was very interesting. I'm speaking today about family law with a particular slant on emphasis on advice we can give to farmers and landowners. I'd first of all like to give an overview as to who we are at Brodies and what we do in family law. Brodies Family Law Team is the biggest family law team in the country. We have a very far-reaching geographical spread, and I personally am based up in the Dingwall office, but we also have a number of specialists in Aberdeen, Glasgow and Edinburgh. We have a very broad range of experience across the team, with trainee solicitors all the way up to partners with over 25 years experience. We also have accredited family law specialists, child law specialists and mediators. We are well versed in dealing with litigating matters, but every member of the team, all 16 solicitors, always try and negotiate resolution before ever attempting litigation. We cover all aspects of family law work. With regard to relationship advice, we advise clients in relation to separation, divorce and dissolution of civil partnerships. We regularly advise on the division of assets and particularly very complex financial provision matters. With regard to that, we'll often bring in external advisors such as accountants and financial advisors to assist with these particular complexities. Clive mentioned earlier about what we can do in terms of assisting our clients with protecting assets before there's even been any contemplation of separation or divorce. And in that regard, we will regularly draft prenuptial and cohabitation agreements, and I'll come on to speak about that in a bit more detail. We also assist clients regularly in obtaining protective orders if they've been subject to domestic violence. We also deal with a wide range, the full range of child law matters. Residence and contact disputes are the main areas we deal with on a daily basis, but we also have solicitors in the team who regularly deal with international child abduction matters. The relocation of children, so that relates to children whose one parent usually would wish to relocate that child from one area of the UK to another, or even overseas. We assist with adoptions and the acquisition and removal of parental rights and responsibilities. We also can assist clients with regard to surrogacy arrangement. I'd like to focus today primarily on marriage, cohabitation, separation and divorce. And we'd start by saying that it may be a surprise for many to learn that the divorce rate in Scotland has actually been decreasing every year since 2006. The reason for that is obviously a societal change, primarily insofar as less people are marrying and more are choosing instead to cohabit. Unfortunately, it's the case that on average 40% of first marriages and 50% of second marriages will end in divorce. And I hope to be able to clarify what can be done to try and ease a situation which might be heading in that direction, or indeed to plan well in advance of ever having to come across that. So the most important thing to be aware of is what constitutes matrimonial property. Matrimonial property is any property accumulated by you or your spouse between the date of marriage and the date of separation. Now, the date of separation is a very important date because that's the date at which all matrimonial property is valued. It is possible for property acquired before a marriage to be taken into account and to be included within the matrimonial property pot. And the most common occurrence of that would be in relation to property acquired with a view to it being a family home. For example, a couple are engaged and perhaps one party purchases a house, but it's with the intention of them living in it together as a family once they are married. That house will become matrimonial property for the purposes of negotiation in the event of a separation. There can be exceptions to the rule that all property accumulated during the marriage is matrimonial, and the two obvious exceptions are gifts given to one party of the marriage to a marriage by a third party, and inherited assets. There's a very important caveat to that, and something which is very important for the viewers of this session to be aware of, insofar as it is possible for these essentially non-matrimonial assets to be converted into matrimonial assets, and this can be done inadvertently without realising it, and is often the case. An obvious example of that would be one spouse inherits a property, and during the course of the marriage they sell that property and then use the sale proceeds to purchase another. The newly purchased property would arguably be matrimonial property and will require to be taken into account in any future division of assets. It's also very important to be aware that in relation to what Clive was commenting on before with regard to partnerships, if you bring a spouse into your partnership, or if you are a business owner and a spouse acquires shares in the business, those shares, even if the business was constituted pre-marriage, the shares given to the spouse will become matrimonial property, and again will require to be taken into account. Farmers, landowners, business owners are often advised to give spouses shares and property in order to mitigate tax, but this is something from a family law perspective we must be very careful about. The law in relation to the division of matrimonial property and separation is very well established and has been in legislation since the Family Law Scotland Act of 1985. This piece of legislation provides a set of rules for the distribution of a couple's capital income on divorce or dissolution of a civil partnership, and I try and simplify this by advising clients it's a three-stage process. The first stage of the process is ascertaining, well, what is the matrimonial property? What is in the pot to be divided? That stage of the process is usually fairly straightforward, but can be complicated if there's a dispute as to whether a piece of property is to be included. The second stage of the process is usually the stage which takes the longest time, and that is to ascertain the value of property as at the date of separation. This will involve parties obtaining, for example, pension valuations, valuations of heritable assets, and bank statements showing how much money is in the bank. All of that can take some time. However, once that is all gathered, we would draft what's called a schedule of matrimonial property, and it's only at that point really that you're able to move on to the third and final stage of the process, which is to decide how the property is to be divided fairly, which usually means equally. The starting point in the law is that matrimonial property, i.e. property which has existed at the date of separation, is to be divided equally between spouses. However, and importantly to note, again, as Hayley mentioned, there are always exceptions to rules, and here is one of them. Important to note that it is possible to justify an unequal division of an asset in the favour of one or other spouse, if that can be justified by special circumstances. For example, if one party uses their own funds to acquire a certain asset, and a good example of that would be if one party contributed a significant proportion of a deposit to purchase a property, for example, £100,000 of deposit, but the other spouse contributed little or nothing towards the deposit, they would have an argument to justify an equal division of the assets in their favour in order to compensate them to a degree with regard to that money they put down for the deposit. So we come across some potential issues when dealing with those matters, and one potential issue is particularly high values of matrimonial property that can take longer to obtain valuations for and can become more complicated and will often involve outside input from, as I say, surveyors and accountants. It also can become an issue if it becomes obvious at the third stage that one spouse will require a significant capital sum payable from the other spouse, and that of course becomes particularly difficult if the capital sum, if there's going to be difficulty in funding that capital sum. Now, the most obvious and common reason for that would be that whilst there may be a significant amount of asset on paper in terms of the matrimonial property as at the date of separation, it can be quite difficult if the capital is tied up in land or business. At that stage, we would require to advise our clients and again take input from financial advisors and other members of the Brodies wider team as to the impact if land was required to be sold off and if that business would suffer as a result of that. I mentioned that I was going to talk briefly about the possible ways we can assist our clients to protect their assets. And I'll go through those. The first is by way of a prenuptial agreement. This is an agreement entered into by both parties before they marry. Now, contrary to popular belief, these agreements in Scotland are indeed enforceable and are legally binding, so long as both parties have taken independent legal advice. The purpose of these agreements is often and usually to ring-fence assets, to exclude them from being included as part of the matrimonial pot. And the benefit of that is that it will prevent distress and the potential for costly litigation in the future. It means that both parties are going into the marriage with a very clear and firm foundation, knowing what the possible end result would be in the event that the marriage did not work out. Obviously, there's an understandable perception that entering into such agreements is unromantic. However, from a legal perspective, and it just makes sense, especially if one or both parties are entering the marriage with fairly significant assets. It's also possible to enter into such an agreement in exactly the same terms, but to enter into it post-marriage. Even if there's never been any contemplation of separation, we would advise clients who have significant wealth to instruct us to draft a post-nuptial agreement. As I mentioned previously, it's no longer the case that marriage is the most common or popular form of living arrangement, and now cohabitation is by far and away the most common means by which couples live together. Since 2006, when the law changed, since then a cohabitant is able to pursue a claim for financial provision on the breakdown of their relationship. I'm often asked, am I a cohabitant? Was I a cohabitant? And the law doesn't actually state specifically a time frame which makes you a cohabitant. The law says that if you were living together as if you were husband and wife or civil partners, then you could be considered to be a cohabitant in terms of the law. In the event a court action was eventually raised, the court would have to consider whether the length of period that the couple have been living together, the nature of the relationship, and the nature and extent of the financial arrangements between the couple when deciding whether or not a couple were cohabitants. In the event that a cohabiting couple separate, the first stage, as is always the case, is that a solicitor will try and negotiate with, on behalf of their client, with the other side of the matter to try and resolve matters as amicably and swiftly as possible. If that's not the case, then it's very important that cohabitants and solicitors are aware that they only have a period of 1 year post the date of separation in order to make a claim through the courts for an award, a financial award. It's also the case that if a member of a cohabiting couple passes away and they do not leave a will, then the surviving cohabitant is able to make a claim upon the estate. Now, that claim, again, if it cannot be resolved through negotiation with the executors of the deceased, that surviving cohabitant has a 6-month period post-death to raise a claim for a financial payment to be made to them. Again, in relation to protecting against these possibilities, we as family lawyers can draft cohabitation agreements, and these help to protect parties who are bringing potentially valuable assets into a relationship from them being subject to any future claim in the event of the cohabitation ending by way of either death or separation. these agreements, as I've mentioned already, the same as prenuptial agreements and postnuptial agreements, are entirely enforceable in Scotland, so long as they have been carefully drafted with legal advice and the parties fully understand what they're entering into. In summary, it's important that everyone is aware that they can take family law advice not only post-separation or post-breakdown of a marriage or cohabitation, but also if everything's fine and just as part of future planning, they can take advice from a family lawyer in relation to any of the aspects that I've discussed today. I'm now going to pass on to my colleague Scott.
Thank you, Sarah. So I'm a managing associate in the land, agriculture and rural business team at Brodies. I regularly act for farmers and other rural businesses that are approached by utility companies looking to install or upgrade equipment on their land. Whilst utility providers have wide-ranging powers under statute and the threat of compulsory powers is often used, there's usually an opportunity to negotiate terms to better protect your interests. Each utility operates under its own statutory regime, and whilst there are many similarities, each has its own set of powers and procedures. Today I'm going to focus on two areas, electricity and telecoms. Both are topical at the moment, with a number of significant electricity upgrades taking place throughout Scotland, and the rollout of new telecoms technology requiring an estimated tenfold increase in the number of telecom sites. So starting off with electricity and the statutory powers available to licence holders under the Electricity Act. As many of you will be aware, SSE is responsible for the network in the north of Scotland, and Scottish Power is responsible for the south of Scotland. Both have a number of projects underway or being planned. Whether constructing new power lines or upgrading existing infrastructure, electricity companies require land rights to carry out these works. For new lines, this will almost certainly require new rights from the owners and occupiers along the route. For upgrades, there will usually be existing land rights in place, but depending on the documentation in place and the circumstances in each case, these may or may not permit the proposed works or indeed the subsequent operation of the lines at a higher voltage. Whilst electricity companies usually seek to secure land rights on a voluntary basis, they have statutory powers to secure these rights by compulsion, and voluntary negotiations often run in tandem with statutory processes. The Electricity Act gives licence holders power to compulsorily acquire land and rights in land. And this power might be used, for example, to purchase land required for a new substation. The Electricity Act also gives licence holders the power to acquire necessary wayleaves, a term you may be familiar with. This statutory form of wayleave permits the installation and retention of electric lines and ancillary apparatus. The key distinction between a necessary wayleave and a negotiated wayleave is that a necessary wayleave runs with the land and binds successors in title. So if you're approached by an electricity provider, what sort of documents might you be asked to sign? First of all, there are voluntary or negotiated wayleave agreements, which typically provide for an annual wayleave payment to be made as long as the line remains in place. These are essentially personal agreements between the parties and will usually fall when the land is sold or otherwise passed on. Wayleaves were historically the document of choice, but more recently there has been a move towards deeds of servitude in exchange for an upfront payment. Servitudes create a real right in property rather than just a contractual right. As such, servitudes offer greater protection and security to the electricity companies, as the land rights do not fall in change of ownership. From an owner's point of view, a servitude may also be more attractive, as it will usually command a higher compensation payment, and in practical terms make little difference to the owner whether a wayleave or servitude is granted, given the statutory protection that comes into play once the infrastructure is in place. Wayleaves and servitudes tend to be used for pylons and electric lines. It's more common to see leases and licenses and similar used for construction compounds, laydown areas and welfare facilities, where exclusive possession is required for a short period of time. Electricity companies often look to secure the rights they require in advance by entering into an option with the owner in exchange for an option payment. This will typically be based on a percentage of the agreed compensation, with the balance to be paid on completion of the grant of the servitude when it is required. This allows electricity companies to secure the rights they require whilst they obtain required statutory consents, allowing them to proceed quickly with the works once the consents are in place. Consent forms are less formal than option agreements, but beware, these forms are often contractually binding and may require the grant of a standard form wayleave or servitude at a later stage. Whatever form the documentation takes, you need to ensure that it adequately protects your interests. The standard form documents used by most electricity companies are heavily weighted in their favour, giving them all the rights they require but without important protections for the landowner or occupier. For example, access provisions are usually widely drafted so that access can be taken over all parts of the farm without any requirement to agree access routes in advance or to use ground protection mats or similar to minimise compaction. Agreements should also contain clear obligations on the electricity company to mitigate, make good all damage caused, and to restore the land to the condition shown in an agreed record of condition. Agreements should also contain provisions dealing with biosecurity, soil handling, and other good working practices. Signing up to any of these documents will have important legal consequences, and it is crucial that you fully understand what it is you're signing up to before you proceed. So my main takeaway for today is do not sign until you've taken advice. And then moving on to telecoms and the new Electronic Communications Code, which came into effect at the end of 2017. The code was rewritten in 2017 to make it easier for telecoms operators to deploy and maintain their infrastructure. Whilst the new code undoubtedly provides operators with enhanced statutory powers, it does not give them carte blanche, and an increasing number of recent court decisions have gone against them. I'll come on to look at both an approach for a new site and an approach for a renewal on an existing site. However, I'll just start by covering the termination of telecoms leases and agreements. In agreeing to the installation of telecoms apparatus, you should be aware that once it is installed, the code makes it very difficult to recover possession and have the apparatus removed at the expiry date, or indeed at any point after that. Regardless of the contractual period coming to an end, code rights continue on a statutory footing until they're terminated in accordance with the code. The circumstances in which agreements can be brought to an end are limited, and a minimum of 18 months' notice must be given. Now, leases for mass sites will typically be granted for a term of at least 10 years, and so if there's any development potential or aspiration within that initial period, the lease should contain a break option allowing the owner to terminate on 18 months' notice if it needs the land back for redevelopment. We would also normally look to include a lift and shift provision allowing apparatus to be relocated elsewhere at the operator's cost. So coming back to an approach on an entirely new site, what rights do the operators have? Well, the basic premise of the code is that operators require the agreement of the owner to install and operate their equipment on land, but with recourse to apply to the Land Tribunal to impose terms if agreement cannot be reached. The court may impose terms if it's satisfied that two access tests are met. Firstly, the prejudice caused to the owner is capable of being adequately compensated by money. And secondly, the public benefit in having access to communications networks is likely to outweigh that prejudice. Access tests are likely to be met in most cases, but of course there will be some exceptions. There's also protection for owners intending to develop their land. The tribunal cannot impose rights if it is satisfied that the owner intends to redevelop and cannot reasonably do so if an order were made. So what terms can the tribunal impose? If the access tests are met and there's no intention to develop, the tribunal can impose an agreement which gives effect to the rights sought, but with such modifications as the tribunal thinks appropriate. The agreement must also contain provision for the payment of a consideration. The new code introduced a new basis of valuation, which was intended to reduce the rents being paid under telecoms agreements. Whilst the consideration or rent is to be based on market value, this is subject to a number of assumptions, the key one being the no network assumption, which disregards the telecom's use. This has led in turn to a considerable reduction in rents for new sites. In the first Scottish case to determine consideration under the new code, Cornerstone against Fotheringham, set the rent at £1,500 for the first year when the imposition on the landowner is greatest, and then £600 for subsequent years. The tribunal recognised that the impacts of the agreement on the owner should be taken into account when assessing consideration. If you are willing to proceed on a voluntary basis, there is often scope to secure better financial terms and include greater protections within the agreement through negotiation. Also, operators are reluctant to increase the rent. It is common to agree an upfront payment for completing the lease quickly. As for the terms of the agreement, the standard form documents used by the operators are heavily weighted in their favour and give the operators rights which go well beyond that contemplated in the code. It is therefore important to limit this where possible to reflect the corresponding provisions in the code. For example, the new code gives operators powers to upgrade and share use of their apparatus with other operators. However, this is a qualified right. It is only permitted where changes resulting have no more than a minimal adverse impact on its appearance, and the upgrading or sharing imposes no additional burden on the owner. The power to upgrade and share relates only to the apparatus covered by the agreement, and this is an important point. It does not confer a right to install entirely new additional apparatus. Therefore, the agreement should specify the apparatus that can be installed and therefore limit what can be upgraded or shared. Operators are usually looking for 24/7 access with little advance notice and indeed no notice in the case of emergency. We normally look to include an agreed access protocol in the lease, covering notice periods and the information to be contained in the notice. For example, personnel or contractors attending, types of vehicles and machinery being used, biosecurity measures, and so on. Moving on to look at the situation where an operator approaches you for a renewal of an existing agreement. As mentioned earlier, telecoms agreements continue on a statutory footing after the contractual term until terminated in accordance with the code. The new code also provides a mechanism for court-imposed modifications and renewals. In this case, either party can apply for the modification, but only after the end of the contractual term. As renewals are subject to the new code valuation principles, operators have been using this aggressively to push rents down on existing sites. However, in the recent decision of EE and 3 against Duncan, the Lands Tribunal refused the operator's request to terminate existing agreements and replace them with new ones at reduced rents, as the operators had failed to make out their case. The Tribunal focused on there having to be needs which justify the replacement of the existing agreements and made it clear that convenience is not enough. The operator's desire to have the new code rights to assign, share and upgrade and to reduce the rents payable under the existing leases did not satisfy this needs test. Whilst this decision is being appealed to the Court of Session, at least for the time being it represents something of a game changer. And if you are approached for a lease renewal or already in discussions for a lease renewal, then you should consider your position very carefully before proceeding further. And certainly do not take it as a given that the operator will be able to reduce the rent or otherwise improve their terms. So that brings me to the end of my talk, and I will now hand back to Clive for questions. Thank you.
Thank you very much. I assume that I'm live again. I'd just like to thank all the speakers for their presentations. We were going to go to Q&A, but I'm conscious that we are running late, and I know that Robert and Claire are keen to wrap up. I would just mention that we have a show offer. If anyone wants a no obligation chat with us, ask any questions, they're very welcome to get in touch with us. And I hope the message that comes out of this for everyone is that yes, there's a lot of stuff to navigate there, but with a little bit of planning, it is possible to get your business in the right shape to survive succession, to survive matrimonial upset, and to survive and to get the right deals in place if you're approached by an operator of one of the utility companies or telecoms. So we'll leave it at that. Thank you very much for listening, and I'll hand you back over to Robert and Claire to wrap up.